items. First, and this is most important, how you're going to obtain CLE credit for your participation today. We've sent you two forms. One is an attorney affirmation for non-traditional course format, and the second is a feedback form. And you need to send both back to one of our staff members, Brittany Counts, in order to receive CLE credit. Her email address is listed on the forms, and you do need to list the CLE codes, which will be given throughout the presentation in order to receive credit. There are two codes, and if you were, I could tell you what they are, but you'll have to see them as they come up. They'll be at the end of the sections. Second, as just indicated, today's program is being recorded, and we will send you a link of the recording and the presentation slides either by close of business tomorrow or on Monday. And third, if you have any questions during any of the presentations, and we do encourage questions, please use the chat box in the lower right-hand side of your screen and type in the question, and we will answer them if we have time during the seminar period or the section period, or offline if there is no time. So we've already sent you the biographies of the presenters, but I wanted to briefly describe who they are today. First, speaking about public corruption and lobbying, we have John Mitchell and Sarah Hall. John is a former Cuyahoga County prosecutor. That's in Ohio, for those of you who are not from Ohio. He's handled and is now handling several federal public corruption cases. And Sarah is a former prosecutor in the fraud section of the Justice Department's Criminal Division, and she too has handled and is now handling a number of federal fraud and corruption cases. Then we're going to go to Fcpa compliance. Joan, Meyer, and Samir Varma will talk about that. Joan is a former senior counsel to the Deputy Attorney General. She's a former federal prosecutor in Michigan. She's a former CFTC enforcement attorney and a former Illinois state prosecutor. She's represented companies and individuals in numerous Fcpa investigations and prosecutions for more than a decade. And basically, Joan is unable to hold a job for very long. Samir, on the other hand, has been with the firm for a long time. He's a longtime trade attorney in international trade. He has deep experience in advising clients in Fcpa compliance and enforcement situations. Then we're going to talk about whistleblowers and securities fraud, and the presenters will be David Wilson and Joan. David is a longtime litigator with a concentration in defending securities enforcement proceedings, and he is intimately familiar with the problems posed by whistleblowers. And last, Samir Varma and I will talk about export controls and economic sanctions. In addition to his Fcpa work, Samir does spend a great deal of time advising and defending clients in export controls and economic sanctions matters. And as for me, I'm a former state prosecutor and federal organized crime prosecutor. I've handled all sorts of cases over the past 43 years, including some of these, but the reality is that I'm basically unqualified, but we needed somebody to do this with Samir, and no one else would volunteer. So before we get to the substantive presentations, I did want to take a moment to present to you some quantitative information. This slide and the next slide are drawn from the Syracuse Transactional Records Access Clearinghouse. And what they do, they use the Freedom of Information Act to request data from the Justice Department and other federal law enforcement agencies, and then compile those statistics into various reports, which are, anyway, fascinating to me. But this tells you, and again, don't worry about what the definition is of white collar, and it certainly doesn't tell you about investigations. It doesn't tell you about regional emphases. But if you just look at it as a directional information, you can see that basically since the end of the Obama administration, the number of white-collar crime prosecutions has declined by more than a third, 35.5%. Now, the second slide gives you the same information, only going back 15 years. The blue line is a 6-month rolling average to smooth out the monthly spikes. And wanted to point out a few portions of this particular graph. First, if you look at December 08, that is, and January of 09, the beginning of the Obama administration, and also the depth of the Great Recession. And so you can see that as you move over into 09 and 10 and 11, that the number of white-collar criminal prosecutions in the federal courts increased dramatically and was a result of the change in administration and also the cases that came out of that crisis. If you move ahead now to the end of the Obama administration and the beginning of the former guy's administration, December of 16, January of 17, you can see how much less emphasis there was in white-collar crime prosecutions relative to the Obama years. And then, of course, if you look all the way to the right, the big gap is from the pandemic, when things basically came to a stop and then sort of resurfaced during the summer and have now declined. So the conclusion from this is that we, in the white-collar world, it has been slow. There have been any number of articles that I'm sure you've read, written by white-collar practitioners expressing their fervent hope that the Biden administration will ramp things up and generate more business for all of us. But we are now where it's a transition and we're still in the pandemic, so it's going to take a while. But what we're going to talk about now qualitatively is what has happened and what can be expected in the future. And there's still time to take steps to avoid getting into the kind of trouble that we specialize in. So having said that, let me turn this over to our first speakers, John and Sarah. John?
Thank you, Norman. Well, again, my name is John Mitchell. I'm a partner here at Thompson Hine in the White Collar Criminal Defense Practice Group. And I think I'm going to be talking about something this morning that most of us were blissfully ignorant of before July of 2010, and that is the use of 501c4s for permissible individual and corporate political speech, and how that runs afoul of quid pro quo allegations, and how the government is now pursuing allegations against elected officials based on this claims of use of dark money and bribery resulting in the performance of their official duties. Next slide, please. It is absolutely no surprise to anybody on this call that public corruption remains a priority for the Department of Justice and for state investigative agencies investigating those crimes. And we have seen the Householder case as part of a significant effort in the Southern District of Ohio, along with, in the last 2 years, we've seen indictments stemming from Dayton area contractors, city employees and council people, Cincinnati council people and others. And heading up I-71 from Cincinnati and Dayton, we arrive in Columbus, where Larry Householder, the former Speaker of the Ohio House of Representatives, finds himself squarely in the middle of the largest public corruption case in a long time here in Ohio, stemming exactly from the use of 501c4s to and their use and participation in the American political process. So what is the Householder case? Well, Householder, Jeffrey Longstreth, one of his aides, Juan Cespedes, and Neil Clark, who are lobbyists, and Generation Now, an entity that is a 501c4 nonprofit, were indicted relating to allegations that they participated in a $60 million bribery scandal designed to further householders' political ambitions and to secure the passage of a controversial piece of legislation known as House Bill 6, related to a proposed bailout of 2 nuclear power plants here in Ohio. Longstreth, Cespedes, and Generation Now have pled guilty to federal RICO charges stemming from these allegations. But really, it's the use of dark money or 501c4s that makes this case and separates it from other quid pro quo claims and other bribery cases that we've seen throughout the year. And there's a real tension here between what is permissible political free speech for individuals and corporations in using 501c4s and how that contrasts with the quid pro quo environment alleged by the federal government that Householder and others purportedly participated in. It's salacious, and the reason it's salacious is because it goes right to the heart of something we see in every political cycle, and that is the claims of dark money and questions of anonymity and who's really behind certain piece of legislation and what sort of access do they have to our political representatives because they are donating money to C4s and other anonymous organizations. And this is going to result, we think, in greater scrutiny of the C4 process, greater examination of how this dark money is purportedly spent or allegedly spent, and how that relates to the performance of official duties of our elected officials. Next slide, please. So I can state with complete honesty, before July of 2020, I was blissfully ignorant of what a 501c4 organization is. But at its heart, similar to a 501c3, it's a nonprofit. And it is designed, and its mission is supposed to be, it is organized for profit, but operated exclusively for the promotion of social welfare. And this 501c4 concept originally was developed in the Revenue Act of 1913, but is now evolved into what we call a present-day 501c4 nonprofit. Next slide, please. So when I think of nonprofits, I always think of 501c3s. And what are the differences here? Well, look, a 501c3, the purpose is it's supposed to be for religious, charitable, or educational purposes, whereas a C4 promotes social welfare. Its taxes are tax deductible for a C3, but not for a C4. And this is really the heart of it, the anonymity provisions. Donors over a certain amount may not remain anonymous for a C3, but for a C4, anonymity is readily available, subject to limits that I'm about to disclose in a moment. Advocacy, the C3 may engage only in limited advocacy, whereas a C4 may specifically engage in issue and candidate advocacy and lobbying. And here's the key that makes this case kind of salacious is what is the oversight? Well, a 501c3 must register with the Ohio Secretary of State's Charitable Law Section, so the Secretary of State has the power to examine the C3 and make sure that it's being operated in accordance with its intended purpose, and those operating the C3 are operating in accordance with the law, where the C4 only has to register with the Secretary of State, and there is significantly less oversight than we would expect with that organization. Next slide, please. Well, what are the benefits and criticisms of C4s, right? I mean, this has been in the paper quite a bit, but the benefits are you can donate to political activities. You can be expressly against or in favor of an identified candidate or issue. And really, this is, again, to highlight the criticism here, donations to C4 are anonymous. And corporations and individuals can back causes and issues that are important to them without fear of adverse press and without criticism of a stance that they may take. And this is extremely important in today's social media environment, where something happens in 1 minute and then is blown throughout the internet 3 minutes later. Again, Ohio requires you to register your C4 within the state, and other states require disclosure as well. But importantly, there's no upper bound on legal expenditures when donating to a C4. Now, this dovetails right into the criticism, right? And you can hear it, and you've heard it over the last, or since July of 2010, and that is, who are these dark money donors? Well, C4s with more than $50,000 in gross receipts are supposed to file tax documents identifying donors, but again, this can be redacted if made public, in contrast to a C3 that has limits in terms of donors of more than $5,000 must be disclosed. So this dovetails right into the government's claim in the householder case that by employing multiple C4s and ultimately Generation Now, there's been a corruption of the political process in Ohio because the amount of money purported to be $60 million in this case directly led to donors getting access to householder and others, enabling householder to identify and back a specific slate of candidates and further his political ambitions and identify those candidates, help them get elected so that they could pass, or as the government claims, a piece of legislation known as House Bill 6. And all this is operating in this dark money environment where there's no light or no regulation, and the ability of the state attorney general to regulate the money flowing there is significantly hampered. Next slide, please. So let me start by saying Citizens United and McCutcheon are both very lengthy decision. Citizens United is a healthy 95 pages, and McCutcheon is 57 pages. So the next few slides, I will readily admit, are not going to capture everything that those cases offer in terms of guidance, but certainly are important for examining the tension between what is political free speech that is permitted and what is prohibited and frowned upon in a potential quid pro quo environment. So these two cases are notable because they've analyzed these tensions, and we think, and I believe, these are kind of the leading cases that identify corporate spending for a political purpose and what is permitted, what really is corporate free speech and are there limitations on that, and what are individual campaign limits in the aggregate and base levels, and how do those fit into a potential quid pro quo framework. So it's interesting, though, and as said here on the slide, following the Citizens United decision in 2010, 501c4 applications more than doubled and skyrocketed because at its heart, Citizens United was a C4. Next slide, please. And look, I'd like to take this point to thank Jacqueline, our host, who's really got the heavy lifting in here because she's got to herd the many cats that are presenting today and keep us on track and keep us matched with our slides. So thank you, Jacqueline. The United States Supreme Court's decision in Citizens United was really, really interesting. And it was because it was for the first time in a long time the United States Supreme Court had examined this question of what constitutes free speech for corporations. And Citizens United was a C4. It had challenged campaign finance laws, limiting its expenditures from its general treasury related to a very critical film it had created of then presidential candidate Hillary Clinton. And, the idea and what the Supreme Court examined was whether a corporation speaks through monetary contributions and what, if any, limits could be placed upon those political donations. And the court specifically held that independent political broadcasting a candidate's election can't be limited. But it also reaffirmed that regulating direct donations to candidates from corporations or unions is also constitutional. But interesting for this case was this idea of how did a C4 involve or interact with that? And as we've seen in this case and others throughout that we'll talk about in a moment, you'll see that this idea that donating to a C4, which is a separate individual entity and organization, has, in the eyes of the Supreme Court, a significantly less chance of quid pro quo behavior because it is a step removed. And it's this kind of tension of really who controls the C4 and what are you allowed to do that's at the heart of the householder case and really has the potential most implications on your organization when folks come to your door knocking on the door asking you to donate to various causes. And all these cases stand for the idea that, quid pro quo bribes are legal and remain illegal. But again, it's this tension between what can you do with a C4 versus a direct contribution and what falls within the realm of political free speech is something that the court has examined. And I think it's going to play out significantly in householder. And it's something that will be at the heart of any political activity that your organization or you choose to take as an individual. Next slide, please. The McCutcheon case in 2014 involved the Federal Election Campaign Act of 1971, and it involved an analysis of what is, appropriate for base donations, i.e., donors to individual candidates, versus aggregate donations, and that are donations made to multiple candidates by an individual. And McCutcheon sought to invalidate the biennial aggregate limit on an individual's contribution to a presidential campaign and a slew of other candidates because they were limited to, in his case, to $33,088. And after Citizens United, the question here became how much money can be used to support a particular issue. Again, this is a healthy 59-page decision, so please don't take this slide as all the relevant material, but this is what is important for our discussion today. It was a plurality decision, and look, it said, hey, look, at the heart, aggregate limits do little, if anything, to address a concern that while seriously restricting do anything to address a quid pro quo concern while seriously restricting participation in the democratic process. Again, this caveat here is that a bribe is still illegal, but it has to be examined in the idea of what is taking place in the political process, what sort of corporate speech or C4 speech is taking place here, and is it permissible in light of potential quid pro quo concerns. And the court continues to view corporate donations as permissible political speech, and it continues to massage this tension between what you can do and what you can't do in light of what's taking place. And so, next slide, please. So we're left with, what are the limitations of C4s? And after Citizens United, and after McCutcheon, what are our takeaways? And Sarah and I have developed some real, what we think, suggestive behavior that you or your organization can undertake that can protect you from the same sort of scrutiny or unwanted government attention that householder, his defendants, and the C4 generation are now facing, right? And so an independent expenditure cannot be made in cooperation, consultation, or concert with, or at the request or suggestion of a candidate's authorized committee, or their agents, or a PAC or its agents, right? So the question here is, hey, look, if you're going to donate to a C4, which is a permissible vehicle for political speech, what is the level of control that is being exercised by the candidate or by those controlling the C4? Is it an alter ego for the candidate that's been alleged in the householder case, or is it truly an independent organization that does not have the type of oversight and involvement that is being prohibited here in our first bullet point? And look, and this shouldn't be a surprise to any, but the court in McCutcheon, again, focuses on that quid pro quo. Like, donations may be made in large sums of money. So even what may seem to be obscene amounts of money are politically permissible in the criminal law context, but not in connection with an effort to control the exercise of an office holder's official duties, right? So what is the level of control again? And is there a direct link between the donation stemming from the C4, which is again a step removed from the individual donations, and the candidate, or is there truly independence there and no sort of wink, wink, nod, nod, quid pro quo relationship? So again, these are broader implications that have been highlighted in front of, by virtue of the householder case, and those implications must be considered when you're thinking about what is permissible for your organization to donate and how you're going to do it. And again, Sarah and I have developed some thoughts for you that you should consider, and I'm going to turn the presentation over to her. Thank you for your time today.
All right, thank you, John. So I'm going to talk a little bit about the compliance aspect of C4s, and whether your organization wants to be a donor, whether you want to be a donor, or just general compliance issues that are suggested by the householder case and the Supreme Court's guidance in the two very important cases that John just discussed. So we know that if you're a donor to a C4, you can remain anonymous, even though you may want to donate more than $5,000 in a year. You have that anonymity. And we also know that a C4 can spend an unlimited amount of money on a specific candidate, campaign, or political issue. the caveat, of course, is that there can't be a quid pro quo. There can't be, the funds cannot be used out of the C4 to upset or influence an office holder's official duties. You cannot have that quid pro quo. But in the criminal context, we really need to look at two questions here in regards to prosecutions involving C4s. How does the government prove that the C4 was being used as a vehicle for a quid pro quo? That's the first question. And then on the flip side, on the defense side, how does an organization or an individual donor defend against any accusations of improprieties or illegalities in regards to donating to a C4? Next slide, please. Okay, so quid pro quo. This is the meat. This is the meat and the heart of what these cases are all about. So we know from the Citizens United decision out of the Supreme Court that just the mere existence of an independent expenditure does not give rise to corruption or the appearance of corruption. It's okay to spend money. That's your free speech rights. We also know from Citizens United that corruption requires a, quote, pre-arrangement or coordination of an expenditure with the candidate or his or her agent. That's going to be your quid pro quo, that pre-arrangement or that coordination. We all know that a quid pro quo is when, you give something and you get something. It's this for that. That is a quid pro quo. So it's giving money in exchange for political action or political inaction. But as we've seen through the way these C4s are permissibly set up under the IRS rules, the donors can remain anonymous. They are anonymous, and having the donation go from the individual or the organization to the C4, generally will provide a level of insulation or cordoning off from the further activities, the downstream activities the C4 may undertake after the individual gives the money. So as the Supreme Court said in McCutcheon, the donor cedes control over the funds to the C4. And so from DOJ's perspective, in terms of the level of proof that's needed to prove up some impropriety or illegality with respect to that donation, the chain of attribution, to use the words of McCutcheon, it grows longer. Next slide, please. Okay, so one of the key issues that came up in the householder case, which of course is still ongoing, is what if the office holder, in this case Larry Householder, what if the office holder is also governing or running or controlling that C4? We know from John's earlier slides that the C4 is a nonprofit. It's supposed to be set up for a social welfare purpose. But what about the situation where the politician is somehow involved in controlling that C4? If the government can prove, as they will attempt to do in the Householder case, that Mr. Householder was controlling the C4, that's going to break that chain. I mean, the chain of causation really goes out the window, because if they can prove that the politician is really controlling the C4, that's going to be very important to their proof. And we know from the Householder indictment, there were some recordings made in the investigation. One of the gentlemen who was indicted, his name is Neil Clark, he's one of the lobbyists. He was recorded as saying, quote, "Generation Now is the speaker's C4. That's the one I work for." The speaker here being Larry Householder. So, that's going to be DOJ's proof that the politician was controlling C4. Generation Now is the name of the organization. Next slide, please. Okay, so the next couple of slides really talk about the risks that that donors face when giving to C4s. The risk, of course, is that, hey, you've got this great C4. It sounds like a wonderful place to exercise my political free speech. Let me give some money to it. But what you really want to know is, is there a politician at the end of the rainbow? Politicians are rarely going to set up the C4s in their own name. it's going to be most likely set up in somebody else's name. As the next set of bullet points talks about, names of C4s are often pretty nondescript. In the householder case, it was called Generation Now. What does that mean? I mean, who knows what that means? It's really nondescript. A couple of hypotheticals we came up with just to sort of illustrate the purpose. The point of this, citizens against really, really bad things. Okay, what does that mean? Nobody knows. It's completely nondescript. So, from the donor's perspective, the name may not really give you any indication as to, is a politician involved? Is a politician controlling this? Who's really controlling this? Let's go to the next slide. And so here are some recommendations that John and I put together. Shout out to Associate Ben Samlin, who assisted with these slides. So thank you, Ben. And again, these are just generalities. Every case is going to be different. There is no one size fits all. So if you have a C4 issue, please reach out to myself or John. We'd be happy to talk to you about it. But these are just very high-level generalities that we offer as sort of a starting point for any analysis, which it necessarily is fact-based. So issue number one, if you're thinking of donating or your organization is thinking of donating to a C4, you've got to properly vet those donations. Questions to ask: who owns the C4? Does a business own it? If it's owned by a business, who owns the business? Where is the end of the rainbow? I mean, that's really what a risk-based approach is going to dictate when looking at donating to a C4. If your organization has lobbyists, what do your lobbyists say about the C4? Is it legit? Is it not legit? I mean, consult your professional advisors, such as lobbyists, to try to understand what's the real deal with this C4. How is the money being used? I mean, that's something that if you're considering a donation, you want to know, where is my money going to go? Because it's not just going to sit in the C4. The C4 is a vehicle for the IRS, wants it to be social welfare. The money will be spent somewhere. The question for the risk analysis is, where is that money going? Okay, the next piece here is, identify your knowledge. Is there any possibility that this C4 is going to be used for an improper purpose? What does the rumor mill say? Are there risks here? So, you want to look at, under questions to ask, who is asking for the donation? Who is soliciting the donation? Is it a politician's agent? Is it a politician, him or herself? When is the election? Are we talking about an election year solicitation? Are we talking about not an election year? I mean, these are things to ask. And, obviously you want to be clear with yourself, or your organization needs to be clear with itself about what is the purpose of donating to this C4. You don't want a quid pro quo. You don't want to be stuck in a quid pro quo. So, be clear about the intent. Okay, let's go to the next slide, which is our last slide. And then this is really in a similar vein. We've called this slide common pitfalls in C4 donations and recommendations on how to avoid them. But the real issue here is, hindsight is 2020. If the C4 that you donate to now falls under investigation later, and the FBI or DOJ gets a hold of written communications, text messages, maybe they recorded some, there's a wiretap, you've got recordings by undercovers. How are your communications with entities, people connected to that C4, how will they be perceived? Hindsight, I mean, oftentimes communications can be vastly taken out of context. So, the solution here is properly document all communications and make a really clear record for yourself. Because if you have that record and you're very clear that this is not a quid pro quo, that we're really just donating for purposes of furthering the social welfare goals or the other goals of the organization, that's going to serve you well if there is an investigation in the future. Under the column that says steps to protect yourself, create a paper trail, and keep that paper trail. Don't let it automatically get overwritten by your email servers or your phone text message retention policy. keep a copy, keep your record. That's your defense. If something comes up in the future and you need to explain the subjective intent behind the donation. So what I'm going to do now is I'm just going to wrap up because we're over our time a little bit. Can I have the next slide, please? So if you have any questions, please feel free to reach out to myself or John or Ben. There's our contact information, and we'd be happy to talk to anyone about this topic. So thank you for attending, and thanks for your attention.
All right, well, thanks, Sarah. I don't know if Norm, you were going to introduce me, but you already did earlier.
Go for it. We're talking about FCPA now. Okay, go for it, Samir.
Yeah, sorry. So yeah, thanks, Norm. Thanks, Sarah. Thanks, John. That was great. Yeah, we're going to talk about FCPA enforcement trends now. I think these are just some of the topics that we're going to hit, that Joan, Meyer, and I are going to hit. Joan was introduced earlier as well by Norman. First, we'll just start off with some recent enforcement actions and statistics looking back over the last 5 or 10 years on some of the stats. And then we'll talk a little bit about the Commodity Futures Trading Commission's foray into the FCPA. We'll look at some of the recent guidance documents that have been issued over the last year or so, discuss a little bit about SEC enforcement trends, and then other sort of recent trends to wrap everything up. Jacqueline, can you go to the next slide? Thanks. This is just a brief look back on enforcement actions over the last few years. The SEC, which is in red, you can tell it's been a little bit inconsistent over the years, and you waver between sort of 10 in 2015 to an all-time high of 32 in 2016, and then back to 10, 17, 19, and then another big drop down to 10 just last year. On the DOJ side, which you expect them to track the SEC since there's a lot of coordinated actions, but not always. The DOJ enforcement actions were generally trending up until 2020. They had an all-time high of 35 actions in 2019, and they've fallen again back down to around 20 in 2020. Norm touched upon some of the reasons for the big drop in 2020 and sort of in the white collar area in general. But, I think what were the reasons for this big drop in the last year? 4 years ago, we probably would have said that we would see different priorities of the Trump administration versus prior administrations. But really, and I want to hear, Joan's thoughts on this as well, it could simply be, changes throughout the DOJ and enforcement policies in general, just in terms of the lack of stability at the top. I think
that's a good point, Samir. Yep. That there really hasn't been, even though that the prior administration, the White House had spoken out against prosecutions under the Foreign Corrupt Practices Act and stated that they were unfair to companies because foreign companies were getting a benefit in the way that they were proceeding, where, again, there was too much regulatory scrutiny against companies subjected to the FCPA. But I do think that part of what is happening here is a function of COVID, and it also is a function of the fact that these investigations take such a long time. Mm-hmm. And so you see a rise and a fall depending on where they are in the investigatory cycle. Is that your experience?
I think that's right. And I think another issue there with COVID is that there could be a lagging effect over the next few years as well, where cases or prosecutors who may have been further along in their investigation, may have taken a hit over the last year simply because the lack of access to documents or the lack of access to witnesses or the lack of travel to do your investigative work abroad. And so there may be even a continued sort of downturn in 2021 simply because those long-term cases can't come to fruition.
Yeah, I do know that the DOJ is trying to do a lot by Zoom, and actual presentations, witness interviews, but to do a thorough internal investigation or even a government investigation in parallel, nothing beats face-to-face assessing a witness's credibility, talking with a witness regarding documents. So it is a little cumbersome here to conduct a thorough investigation into the allegations.
No, that's right. Well, I think that if it wasn't for Zoom and WebEx and things like that, we may not have had this webinar today, given the weather and everything. So it does help in some way. Jacqueline, can you go to the next slide? So this is just looking at the government's requirements. This was actually taken from a Stanford Law School website, which is a great website to look at for these data for this data. It basically shows when the government has required certain compliance obligations, like adopting new policies and procedures upon companies who are resolving FCPA related violations. You can see it's been pretty consistent over the last 10 years, right around 70%. In fact, 100 out of the 142 cases is right at 70%. But I think what this slide or this graph doesn't show is how companies are getting better at compliance. And so even though these compliance obligations have been imposed upon companies, the actual compliance obligation is much different today than it was 10 years ago or 20 years ago or 25, 30 years ago. It's sort of there's a new standard, a new raising of the bar for compliance. And so the compliance obligations that are placed in 2020 are a lot more stringent than the compliance obligations that were placed in 2010, even though it's been pretty consistent. I think, Joan and I were talking about how we expressed a little bit of surprise that it's not 100%. That 100% of the companies haven't been, imposed compliance obligations, but.
Well, now that the government has gotten into the compliance game, it's an important feature of every government presentation. If companies making a presentation, they have to include a component for remediation. Years ago, the DOJ would look at what was the pre-existing compliance program before the violation occurred and try to assess that. But now it's equally as important to show the government when you're in front of them that you have remediated during the course of the investigation and closed the gap that problem in the first.
I think that's right. I think that is going to continue. I mean, regardless of when the government's going to be requiring that going forward as we in the future as well. Jacqueline, you want to go to the next slide? Thank you. Yeah, go ahead, Joan.
So even though you see FCPA cases on a decrease during this time of COVID, the government has still managed to bring some very significant cases. And as you can tell, the penalties are getting higher and higher. The most significant case I think they've brought ever is this Goldman Sachs 1MDB case, which dealt with billions of dollars that were essentially siphoned off of a sovereign wealth fund in Malaysia. The facts involve two Goldman bankers that got that associated themselves with a rather shadowy character named Zhao Lo, who was a Chinese businessman and a Malaysian national. When the sovereign wealth fund was created, they were actively pitching business to the fund, and they acquired significant business. They basically helped the fund acquire an energy company. They underwrote a number of bonds. There were 3 projects, and they underwrote those bonds and got another investment company in the UAE to guarantee those bond offerings. And they also became a global front runner for an initial public offering. All in all, Goldman Sachs raised about $600 million in fees in this relationship, and they raised about $6.5 billion for the sovereign wealth fund. But in the way they did it was, and got the business, was that Lesnar and his coworker were working with Lowe to funnel bribes. And in fact, they estimate that approximately $2.7 billion was funded out to pay Malaysian officials and UAE officials, including the former Prime Minister of Malaysia, who was convicted and is currently undergoing a second trial, who is estimated to have received about $700 million from this. The, the, the Goldman eventually settled for a deferred prosecution agreement. There was no monitor imposed, but the total in U.S. penalties was $3.3 billion. And that was after Goldman settled with the Malaysian government, paying penalties of $2.5 billion, plus a guarantee to Malaysia that they would back the recovery of assets to the tune of about 1.4 billion. So we're talking about huge numbers here. Lesnar was convicted. He pled guilty and agreed to a forfeiture of about $44 million. His coworker is going to trial, and Zhao Lo, that shadowy Malaysian intermediary, is still on the run, although strangely enough, his attorneys have negotiated a return of about $900 million back to Malaysia. When Goldman's entered into an agreement, a subsidiary in Malaysia pled guilty. Some of the interesting features about the agreement that Goldman did not receive voluntary disclosure credit because they weren't self-reporting soon enough for the government. Obviously, it wasn't a timely disclosure. And the second thing is that they received partial cooperation credit because the government took them to task for, while cooperating in the investigation, there were significant delays, including the untimely production of certain tape recordings that showed that the bankers were paying bribes and conversing with Lowe about it. It was a complicated case. There are still obviously individual prosecutions going on, both in Malaysia and in the United States. But it is a significant prosecution because not only were the numbers so large here, but you had many jurisdictions participating in this, getting millions of dollars. So the Federal Reserve got about $150 million, that another U.S. agency, the UK, Singapore, and Hong Kong, in addition to Malaysia. So very expensive for the bank, and it tells us something about compliance, and tells a compliance tale about what the bank should have done to investigate these transactions in a deeper way than they did. Next slide. The CFTC, which is the Commodity Futures Trading Commission, is now in the game with the Fcpa. They had essentially been sitting on the sidelines. They always worked with the DOJ on criminal cases involving violations of the Commodities Exchange Act. But in 2019, they issued an advisory that urged unregistered individuals and entities who saw corruption-related violations of the Commodities Exchange Act to come in, and if they voluntarily disclosed and self-reported to the CFTC and the DOJ, that there would be a presumption that they would not be assessed a civil monetary penalty. They'd still be subject to restitution and disgorgement if applicable, but the presumption would be, if they cooperated and aggravating factors didn't exist, that they could walk away with no civil monetary penalty. And what we saw in 2020 was a settlement with an energy company, Houston-based, called Nepal, that was proceeding that involved the DOJ and the CFTC. The DOJ what got an agreement from the company and a penalty of 135 million. It involved 3 Latin American companies in Brazil, or countries in Brazil, Ecuador, and Mexico, and their state-owned oil companies. Vitol was paying bribes to certain officials in those state-owned companies to get confidential market intelligence and also competitive bidding information that they were not entitled to procure contracts to purchase oil. They ended up using sham companies, paying sham consulting fees to get that done in these 3 countries. And the activity actually continued, especially in Mexico, up until 2020. At the same time, the DOJ entered into the agreement with Vitol. The CFTC was looking at Vitol's market manipulation in the commodities futures markets that was predicated on the fact that they had taken these large contracts of oil from these companies. So they obviously had a favorable advantage and were able to manipulate markets. The CFTC settled for a cease and desist order and $95 million. So that was the first foray by the CFTC into an FCP related investigation. Next slide.
So in 2020, there were a number of recent guidance documents that were issued by the DOJ. I think the first one we'll talk about was the update to the FCPA Resource Guide. The FCPA Resource Guide was a joint document by the DOJ and the SEC that was issued about 9 years ago, or 10 years ago now. They updated it in July of 2020. You know, there wasn't anything really groundbreaking. But it did update the document related to sort of recently issued policies and cases. One of the things it did was it set forth certain factors for how you view state-owned enterprises or instrumentalities of the government. There was a reference, I think, to, or a referral, I guess, to the Hoskins case, which was a well-known Second Circuit case limiting the DOJ's ability to pursue foreign nationals. Basically, that case was that foreign nationals must be an agent or domestic concern, rather than getting caught under some sort of co-conspirator or aiding and abetting liability theory. You know, the government, even in that situation, though, I think noted that there was other precedent out there with other circuits that sort of went against that rule. And so, I mean, I think that brings up a good point with these guidance documents, that they're still written by the DOJ and the SEC, and it's sort of those two are the enforcement agencies of the FCPA, and it's still their viewpoint. So even when a case sort of goes against them, they offered up another sort of precedent that was out there that may actually go in their favor and still can allow them to construe these laws pretty broadly, which was pretty interesting, I think.
Yeah, it was really, and they also have so many statutes that they can use when bringing a prosecution. So it's not only bribery, like Hoskins, he may have gotten out from under the bribery related charges because he was not in a category enumerated by the statute, but he still was convicted of money laundering.
Yeah. So, and then even in that document, they did do a little bit of a sort of nod towards internal controls and compliance programs and things. But really, the document that was geared towards the compliance program issue was the DOJ's evaluation of corporate compliance programs, which was updated in June of 2020. It's basically their statement of the factors that DOJ considers when conducting an investigation or sort of determining whether to bring charges, negotiating the final agreements, the resolutions. Noted in that document, it's you know, I won't go into sort of the main detail of it, but they use a lot of sort of the same buzzwords and same best practices ideas that that companies consider when looking at their own compliance program. You know, they talk about whether the compliance program was well designed or being applied in good faith, or whether it works in practice. You know, it can't just be sort of this program that sits on the shelf and never looked at.
I think too, some of the more important features kind of buried in this document have to do with the company's ability, or the government's expectation that a company is going to keep metrics on things so that they're accessing data, that the compliance department is evaluating data to show whether or not the program is effective. And I think that that's what the government will be looking at in the future, especially for larger companies that have the capability to, you know, look at outlier transactions, access data from other business units, and develop that data for both the risk assessment purposes and when there's a compliance failure, doing what they call a root cause analysis to determine what actually occurred.
No, and that's right. And using the data to make sure that your program is appropriately tailored to the highest risk areas, both from a country perspective or an individual perspective. Also in 2020, the DOJ released its FCPA opinion 20-1, which was in August of 2020. You know, this document, it was released, you know, using the DOJ's barely used opinion procedure release mechanism, where companies can ask the DOJ for a certain opinion, give them certain facts, and see what the DOJ states in response. It's really rarely used. In fact, this was the first opinion that was released in 6 years, since 2014. It had been used periodically for about 10 to 20 years before then, maybe 1 to 2 a year, but there hadn't been one in the last 6. This one, it was basically the opinion advised an investment advisor that the DOJ did not intend to take any enforcement actions related to the payment of certain fees to a foreign investment bank, which was indirectly owned by a foreign government. But it didn't really offer any other real insight. And the real sort of key point was why? Why hasn't this been used more frequently? And why did it not offer up as much insight? I mean, I think the real reasons could simply be that first, the resource guide has been released, and that shows DOJ's viewpoints anyway. The second could be that just the length of time it takes to get this opinion back from the DOJ, but maybe perhaps most importantly, you know, getting an opinion doesn't preclude the government to starting an enforcement action. You're basically asking the government for an opinion without getting any of the benefits of a prior disclosure or anything like that. And so I think that's, you know, kind of problematic here. And maybe that's why it hasn't been used at all.
Yeah, I think companies are very reluctant, and understandably so, to invite the government into their living room. And the government gives many caveats in issuing the opinion. If they don't have access to the complete set of facts, obviously the opinion constitutes no bar to a particular prosecution. And I think it's safe to say that most companies would rather have their counsel sit down and evaluate the situation and give them guidance based on the guidelines and other pronouncements in the cases that have come out of the DOJ, rather than going to the DOJ directly.
And that's right. Jathan, next slide, please.
So we haven't talked about the SEC, very big agency in the FCPA space. And some of the more interesting things that have come out of the SEC recently, and I won't spend too much time on the amendment to the Whistleblower Program because we'll be talking about that in the next session. But the SEC has a very defined whistleblower program under Dodd-Frank, and it obviously processed whistleblower complaints to the SEC to make determinations as to whether or not there are securities violations. there have been some ambiguities in that program, and the SEC is attempting to clarify those ambiguities by amending the program rules, including expediting procedures to move these tips or these whistleblower complaints along. One thing that the SEC has done recently, involving actually an insider trading case, not an FCPA case, is was a dissent by two commissioners as to how the SEC is looking at the FCPA's internal controls provision. These two commissioners have brought up a point about its use and have expressed concerns that it's very, very broadly used, and that the agency is not confining a violation to internal compliance controls or internal accounting controls, but is using the provision to deal with all manner of compliance issues. In the case, a company was repurchasing about $250 million of stock from its shareholders, according to a prearranged stock plan, at the same time that they were actively considering a merger. There was some issue as to whether or not they were using non-public information. Their legal department said no, went ahead with the repurchase agreement, but the SEC started investigating the company for insider trading. They couldn't bring that case, but they brought an internal controls case. And these commissioners basically said, look, that provision is really meant to address the disposition of assets, the proper recordation of transactions that implicate the veracity and accuracy of the company's financial statements. It's not the internal controls violation. The way the SEC saw it was there was an abbreviated informal process to consider the acquisition, the merger, which resulted in a deficient understanding by the legal department that as to how the merger would affect the repurchase agreement. And on that basis, they brought the internal controls violation. Commissioners said it's not accounting, that's a general compliance issue, and we shouldn't be using our internal controls provision that way. Very interesting opinion, and it has implications in the FCPA space as attorneys that are company attorneys forced to go before the government and arguing against internal controls violations are going to be trying to confine it to financial improprieties rather than this general compliance and ethics inquiry that the SEC seems to be leading towards. Next slide.
So I think, just in the interest of time, I think we'll run through these pretty quickly. But in particular, I think the first thing, I know, Joan, you wanted to talk about this, but really the lack of monitorships I think for the first time ever, maybe that 2020, there were no monitorships imposed as a penalty to any of the enforcement actions. Which is a pretty interesting trend.
Yeah, I think that after the recent guidelines that Benchkowski, the former AAG, issued, there was a focus on the costs of the monitorship, whether or not the company could self-report, and the DOJ's seeming recognition that some of these monitorships have imposed quite a burden on companies who are trying to move forward, remediate, enhance their programs. So it may be a move towards allowing companies the freedom to be able to do that themselves. And remember that in agreements where there is no monitorship, the DOJ customarily requires self-reporting by companies. So they do have the ability to monitor how the company moves forward on the compliance side.
Yep. I think moving ahead, I think maybe we can touch upon sort of a new approach under Garland, assuming that Garland gets confirmed. What are some of your thoughts on that, on how we're going to move forward?
I think that we'll see at the Fcpa unit continuing to grow. It's been a very successful initiative by the DOJ. I think we won't see much of a change in bringing cases. The shifting of priorities won't impact the Fcpa to any great degree in my mind. And I think that companies will continue to be pushed to, put together better compliance programs to integrate their financial internal audit and compliance staff so that they know what each other is doing. So we'll see additional guidance because we've seen it from every administration in the Fcpa space. And I don't imagine that things will change much.
Agreed. So I think that's the end of our portion of the presentation. Jacqueline, you go to the next slide. If you all have any questions or anything, or any comments, or anything else, please feel free to reach out to Joan or myself about anything we discussed today.
And I think we have a code.
Oh yeah, there you go.
The tracking code is WCC218.
And that's for the first hour for CLE credit.
So thank you very much. And again, if you have any questions, please contact us.
Thanks, everybody.
Okay. Joan, don't go anywhere. And I think we have David also, right?
Yes.
Okay, take it away.
Okay, so we're going to talk about whistleblowers and securities fraud. Joan already enough about whistleblowing, but I'll pass it off to Joan to start with to just kind of review the general bidding about what whistleblowers are, which can be the bane of companies' existences, but something you really have to pay attention to. So go ahead, Joan.
Well, whistleblowers are an important vehicle for the government these days to find evidence of violations. And as we'll talk about today, the interesting thing about some of these statutes on the slide is that they provide that a whistleblower will actually receive financial compensation for their reporting of violations, which allows the government to move forward and collect sometimes very, very large sums of money from companies that violate the law. The DOJ has the False Claims Act, which is an act essentially that provides that false claims made to the government for compensation, for reimbursement. You see it in the healthcare field where their companies are seeking reimbursement from federal programs like Medicare. You see it with defense contractors who, government contractors who have government contracts and are submitting false invoices for reimbursement. That is a situation where a whistleblower can file an action known as the QUITAM or QUITAM action, either as a private entity or as a private individual, and seek government intervention in this secret complaint filed in federal district court. If the person is successful and there is a recovery, they can get a reward. Similarly with OSHA, the Internal Revenue Service, the CFTC, and the SEC, they have similar bounty provisions, and also many states now have QUITAM laws, which allows a whistleblower to report violations of state law that entitle them to a reward. Next slide. Next slide. David and I could talk about the basics, but we talked about incentives for employees and others that have knowledge of a violation to report both in the federal and state level. And these bounties that they can get can be up to 30% for violations, either through actions that are brought by the state agency or that relator litigation I talked about, where the relator, the key TAM relator, can go into court and file under seal and start an action, which the government can then intervene in if it so chooses. If not, the relator can continue litigating it and try to seek recovery. Some of these statutes provide for anonymity. That's obviously very important for a whistleblower. And as we'll talk, these statutes protect whistleblowers from retaliatory actions taken by their employers with significant anti-retaliation provisions. Next slide. So one of the samples here that we can talk about, which is a very, very active whistleblower program, is the whistleblower program that was started under Dodd-Frank. It rewards whistleblowers who provide original information leading to an enforcement action that recovers more than $1 million. And the whistleblower can receive 10 to 30% of what the Securities and Exchange Commission collects. But like a lot of these, this has to be derived from independent information the whistleblower has or independent analysis that the whistleblower employs that could potentially take publicly available information and employ some sort of confidential analysis to that, which would allow them to say that essentially the independent analysis is original information that points to a securities law violation. The SEC looks at other factors in determining award, both positive and negative factors that depend on what the award, how significant it is, the information, the culpability of the whistleblower, that is, did they participate in the misconduct, and the extent of the whistleblower's assistance. The SEC does enforce the anti-retaliation provisions for the whistleblower. It's really important to underscore that there was a recent Supreme Court case that required the whistleblower, if you're going to take advantage of the anti-retaliation provisions, you're going to have to report directly to the Securities and Exchange Commission. That came from a Supreme Court case, and it was recently clarified in amendments to the SEC rules related to whistleblowers that just came out recently in September of 2020. Certain important points here with the 2020 clarifications is that whistleblowers now must report directly if they want to take advantage of the anti-retaliation. There is now a streamlined procedure for whistleblowers that are reporting violations worth $5 million or less to actually get a presumption that they're entitled to 30% of the award of the recovery. So they'll get a 30% of the recovery that the SEC obtains, and that's going to allow things to move a lot quicker because the SEC has been criticized that it's not moving these whistleblower complaints quickly enough. It also has clarified that the actions that for which a whistleblower can get a award can be deferred prosecution agreements, non-prosecution agreements, and other types of settlements. They don't have to be judicial or administratively filed actions. And the final thing I think that's important about these new amendments is that they clarify that independent analysis, meaning if an individual or entity reports to the SEC, it may be publicly available information, but if the SEC, if the whistleblower adds something that goes beyond what the SEC could ascertain based on publicly available information, that whistleblower may qualify for an award. And in fact, David and I were talking about the fact that just recently, a whistleblower that did such an analysis received $1.1 million from the SEC just in the last few months. David,
let me just also underscore another point, which a few years old, but I believe the Exchange Act rule that we refer to here has to do with settlements and severance agreements with people in which there have been a few enforcement matters in the past where the SEC has come down hard on companies that had confidentiality provisions in separation agreements with employees or executives. The idea being that you can't have some provision in a settlement agreement with an employee that says that they can't report to the SEC. Companies have been slapped for having those provisions. The other thing is whistleblower awards are always confidential. You see these big numbers and you can't really figure out who it is because the decisions that are posted on the SEC website are pretty sketchy in terms of who it is or even what the company is that the whistleblower was blowing a whistle on. Ready for the next slide?
Other thing too, yeah.
Okay.
Next slide.
Joan, did you want to add one other thing before I talk about escalating volume?
I just wanted to add that, and just to follow on to your comments about employment agreements, take a look at severance agreements as well, not only for confidentiality related to any third party, which has to include exceptions for government agencies. So a whistleblower always has to be free to go to an agency and report, but also the SEC has brought some cases related to severance agreements, which specifically preclude whistleblowers from collecting on a whistleblower award. And the SEC has also found those types of provisions to be, worthy of scrutiny and a penalty. So take a look at any documents you execute with your employees before they leave.
Okay, so we've talked a lot about whistleblowing and why are we doing that? Well, you just look at the numbers. One of the reasons the SEC did what Joan was talking about in terms of refining some of its rules is just because the volume of complaints and tips that they're getting is so large. The $3 billion number here represents awards that have been paid to whistleblowers over the last 10 years. And the rate of increase is really pretty staggering. 6,900 tips in the last fiscal year. The SEC's fiscal year ended at the end of September of 2020, and it was a 31% increase over the previous fiscal year. The number of awards is going up. As it says here, 39 awards, which is 3 times more than in any previous year. And even in this fiscal year, which is only a few months old, already been 20 awards for almost $175 million, which is a lot, obviously. Now, tips can come from anywhere. They usually come from people inside the company, but there are instances, and I was involved in an investigation a number of years ago where the tip actually came from a competing company who thought that the accounting at the client I was representing was not kosher. So it can come from competitors, from foreign sources, particularly in the Fcpa context. Another thing is just all you got to do is go run a Google search on whistleblowers, and you're going to see a list of plaintiffs' lawyers who want to help people with whistleblowing. So there's a lot of encouragement out there trying to gin these things up. The SEC trumpets the success of this program a lot, so there's a lot of publicity about it. You go to the SEC's website, and there are plenty of opportunities to lob in your tips. One thing that I thought about when I looked at the number of tips versus the number of awards, and the temptations to say, well, okay, so maybe there's about 7,000 tips in a fiscal year, but there's only 39 awards, so most of these tips must be garbage. Well, that is, I would say that likely, although there are no statistics on this, that the majority of tips don't have a lot of merit, but that doesn't mean that they're not distractions for the company. We'll talk about sort of collateral consequences as we get through some of these slides, but each one of these tips gets reviewed by the SEC. Sometimes companies are asked about them. There'll be an informal request to a company for information about these things. And so there can be investigations that are confidential that we never hear about, and yet they still are instances where companies have to get in and deal with the agency, or even if there isn't something reported. For those of you who are in companies, I'm sure you have a tip line and a confidential hotline, and you see increasing numbers of people raising complaints, raising issues, and these things all have to be investigated, particularly in this climate. Let's go to the next slide. Go ahead, Joan.
I had a situation where a whistleblower came in with about 50 allegations, and the government agency, even though 2 of them were meritorious, each one of them had to be reviewed. So it can be very, very resource intensive for companies to do that.
So the SEC has been asked, sometimes we go to these conferences, which are all remote right now, but they get asked, well, why are you seeing these increases? Is it that there's more fraud in companies or what? And this is all speculation, but the SEC people say, well, it may be because more people are working remotely. There isn't the pressure of sitting next to somebody who they're going to rat out. There isn't concern that, if they're on their own computer, somebody's going to walk by and see that they're raising a tip to the SEC. They've also said, well, it may just be that because people are at home, they sit back and they think about stuff, or they feel insecure in their job. And so they think, well, if I make a report, it's going to protect me as a whistleblower. So again, that may have be another motivation. The other thing, the SEC has put out some pronouncements and made statements at conferences that say that, given some of the wild gyrations in the stock market, there are instances where people are concerned about what their companies are doing. And so there may be, the SEC believes that there have been some violations with respect to stock manipulation, and perhaps that's at the basis of some of these things. Nobody knows for sure, but the point is the volume is increasing. Let's go to the next slide. So I mentioned collateral consequences before. Okay, so, relatively few tips lead to rewards, but that doesn't mean that these tips aren't part of what the government is doing. Sometimes they get tips from people. It is reinforcing information that they already know. And, sometimes there are instances, and there have been a few suits from individuals who have said, I should have been paid a whistleblower bounty. Those, we don't know the details of that because, again, the whistleblower is entitled to remain anonymous. But some of these tips do involve situations where there's been an investigation. Sometimes the investigations occur and they lead nowhere. They drain the company's resources, take up a lot of time. Sometimes the issues that are brought up the whistleblower goes to a plaintiff's lawyer and there's securities litigation. Some of the tips get referred to other agencies. And, as we'll talk about in a minute, for those of you who are in companies, I'm sure you've had internal investigations of internal whistleblowing. And certainly if you get an inquiry from the SEC, you're going to do your own investigation to try to figure out what's this all about. As we've been talking about, this anti-retaliation point is a really important one. We'll get into that a little bit more in the compliance section, which we'll get to in just a minute. But it is something you've got to be aware of all the time when you get these whistleblower complaints, because at least my experience is when we get contacted by a company about a whistleblower complaint and they need outside help, one of the first things I'm asked, even if people are aware of the anti-retaliation provisions, they say, I wonder where this is coming from. This must come from, and they sort of narrow down a group of people who it might be coming from. There is that huge temptation, and you kind of have to do it because you have to figure out who knows what so you can investigate, but you got to be really careful when you go into trying to figure out who it is. Let's go to the next slide. So I was going to turn this part over to Joan again, just to talk about how you protect your company.
So to follow David's comment, it's very important to make sure that you don't violate anti-retaliation provisions. And the way to do that, obviously, is to make sure supervisors are aware of the fact that they can't retaliate. When you receive a complaint, you have to act promptly for a host of reasons, one of which is depending on the seriousness of the violation. If a whistleblower is not actually listened to, that whistleblower might go directly to the government agency without giving you, the company, a chance to investigate. So acting promptly when a complaint comes in is very important. As we noted with the recent Supreme Court decision, Digital Realty, and a change in SEC rules, there's now, to take advantage of anti-retaliation provision, the whistleblower has to go directly to the agency. If the whistleblower isn't anonymous, very important to interview the whistleblower and get all the facts that you can. Many of these things can come in as general allegations, and that whistleblower has more information but hasn't included it in his or her email or letter. If that person is anonymous, don't try to determine the identity. I've seen many outsourced situations where you've got a vendor handling a hotline, or in-house they're handling a hotline, where there is the ability to be able to dialogue with an anonymous whistleblower to get additional information. Get what you can. Do not put the complaint aside, and make sure that you document. And that is who you talked to, what did they say, what documents did you review, making a determination as to whether or not the claim has merit. And if you've got that file, you've got that record, and the whistleblower does end up going to the government, you can show the government what you've done. Next slide. So the other important points in dealing with a whistleblower, which can be a bit of a trick bag, because many of the situation I've seen, and David, I'd be interested in hearing what you had to say. You've got a disgruntled employee who may have performance problems and could have a valid whistleblower complaint or not, but you're dealing with that. And you have to make sure that whatever you're doing is not violative of the anti-retaliation provisions of Dodd-Frank. it's important if you're going to keep the whistleblower from demonstrating to that person that the company takes it seriously, and that is keeping that person apprised of not necessarily the substance of what you're investigating. You don't want to do that, but the fact that there is a process, that a process has been undertaken, and that the matter is being investigated. So the whistleblower can have some assurance and trust that the internal hotline process actually works and the company is serious about doing something about their claims. But eventually you're going to have to decide based on the significance of the allegation as to whether or not to self-report to, in this case, the Securities and Exchange Commission, if there's some reason if it's pervasive, if it's serious, and pragmatically, if the whistleblower is going to the SEC anyway, it's important to show that and for a potential reduction in any penalty, should the misconduct be proven, that you're self-reporting to the agency.
Yeah, and I guess I would say too, this goes to this question of how do you build a culture within a company that tells people that you encourage them to come forward with problems, encourage them to keep it in-house so that you can be more in control with the message, and you can make the decision of whether you've got a violation where you need to go to the agency. People have speculated that one of the reasons you've got more whistleblower complaints is that there's just less loyalty to individual companies in this day and age with people changing jobs so quickly. There could be a lot of reasons for that, but this goes to this question of what kind of a culture do you have in your company, and what are you doing to try to engender loyalty, so that people will feel like, I'm going to keep it in-house, report it, and as long as I know that it's going to be taken seriously if I do have a sincere complaint, and that's why, as Joan said, it's you can't sort of violate the confidentiality of the investigation, but you can tell the whistleblower, we're taking your complaint seriously. These are some of the things that we're doing, not specifically, but we are investigating, and here's where we are in our investigation. Should we go to the next slide?
So how you report and what you're doing to facilitate an investigation is obviously key. That not only, as David says, are you empowering employees to make an anonymous report that the company is going to follow up on, but you also have to have a mechanism where managers are reporting up to the board or audit committee, the audit committee, special committee, any committee that is dealing with compliance matters, so that your process is effective. You're investigating and resolving and making findings with these complaints, or you have a reasonable basis to summarily dismiss the hotline complaints with little or a truncated investigation. Depending upon the significance and the materiality of the complaint, it raises the question as to how you communicate with your external auditors, who clearly are certifying the accuracy of your financial statements. Very often in these circumstances, and David and I have been in many of them, the investigation, the company has made a decision to be very cautious, protect the investigation, being able to assert attorney-client privilege, which could be waived by communications with your auditors. So it's kind of a delicate dance you do with the auditors. Some firms in certain circumstances will be requiring more substantive information. Others would be content to deal just with learning about the process of the investigation without the substantive findings until you're ready to disclose to regulators. These issues are especially important working during the time of COVID, where everybody is working remotely. Next slide. So back to David's point, really dealing with whistleblowers is important because you're setting a tone at the top. Executive management has to indicate that they take this issue seriously and they're committed to their anonymous reporting mechanisms, and so that employees will have the trust to know they can use them and they won't be retaliated against.
You know, and I guess the other thing I would say is it's probably elementary here, but for those of you who deal with these kind of whistleblower situations, you know, involve people who are well steeped in employment law in these situations, because can be a very delicate situation, particularly where you've identified one way or another where the complaint is coming from, and you have anti-retaliation issues. You know, you just don't want to get caught up in a situation where somebody can say you retaliated for a good faith report. If it's a bad faith report, there are other considerations and you have to deal with that. But I think that's pretty much our presentation. Obviously, we'd take any questions, or if you have questions for us offline, feel free to be in touch.
Thank you.
Thank you.
Thanks. Okay, we're up to export control, sanctions, and other things. And Samir, you want to start off with that?
Sure. Thanks, Norm. And I just want to say, David and Joan, great job on those transitions in the presentation. Where I thought we were lawyers, we're not supposed to have that in our repertoire, but so I apologize to everybody that we're not going to have any more of that going forward. But so for export controls and economic sanctions enforcement considerations, I thought we'd start off with just talk about a little bit about sort of a baseline understanding so that we're all on the same page, and why, you know, in certain cases, what's often considered sort of a civil enforcement area can go criminal. You know, obviously for the criminal aspect, there is the knowledge threshold of know or reason to know standard, you know, and the real issue here is that knowledge is often imputed to the company if any of its employees has information regarding violations of export control or economic sanctions laws. There's no such thing as willful blindness here, and so often companies are caught because, you know, the failure to act in sort of the face of red flags could be considered evidence of willful blindness, and so often civil actions do go criminal. I think one of the biggest issues here is just the sheer number of agencies involved in this. You know, there's a number of ways to get caught by different agencies for export controls and economic sanctions. Obviously, there's the Commerce Department's Bureau of Industry and Security that regulates the exports of dual use items, or those items that have both commercial as well as non-commercial use, military use. There's also, obviously, there's the State Department's Directorate of Defense Trade Controls that does the defense article side. There's the Treasury Department's Office of Foreign Assets Control, Ofac, which we'll talk a lot about during this presentation. There's obviously the DOJ gets involved, so there's just a lot of ways. There really are multiple types of violations here. It's not just sending it. There's obviously the end user one, which there's a whole host of denied party lists who you can't do business with, even those individuals or entities that you can do business with, but the way you transact with them must be through a certain method or a certain manner. But there's more than that. There's also there's end use considerations in terms of when you are sending products or exporting products abroad, how that product could be used by the particular user. There's end use restrictions that way. There's also, obviously, there's end destination restrictions. A lot of people think about this in terms of the comprehensively sanctioned countries, which are the Iran, Syria, North Korea, Cuba, the Crimea region of Ukraine, which is basically there because of Russia's annexation or occupation of that territory. But there's also country restrictions for selectively sanctioned countries, which could impact how you do business there. I mean, we'd often talk about Venezuela in terms of interacting with the government of Venezuela, or China, which is obviously in the crosshairs of for the past few administrations and will likely remain so in the crosshairs. There's other ways you can get caught in sort of the criminal enforcement area, which is deemed exports. Deemed exports are those exports of products that never really leave the border, right? It's release of technology in the United States to non-US nationals. Norman and I often bring up this famous case years ago of the professor from Tennessee, Professor Roth, who went to jail for providing technology to Iranian and Syrian nationals and his students who were helping him work on these control projects that were a part of a government contract. I mean, he went to jail for that. And so obviously penalties can be severe. It's not just jail time, it's monetary penalties. There's a lot of civil penalties including debarment or suspension of government contracts. Your goods can be seized, or you lose the ability to transact outside the United States, which is often a big deal. Next slide, please, Jacqueline. Thanks. So some of the recent trends, it's not a trend at all, is the countries of interest don't often change. We talk often about China, Iran, Russia. Those we will still be talking about. Those are the countries that are sort of in the crosshairs and will continue to be so. That's the way, as we go through our statistics, we'll see that more and more. Recently, there were military end use and end user restrictions, which is a new standard for exports of products that could be sent to these military end users in China, Russia, and Venezuela, or for a military end use. This created a lot of havoc at the end of last year in terms of how companies determine whether their products are being used for a military end use in these countries or by a military end user in these countries. The government has tried to assuage some people's fears about this by issuing lists of companies that fall under this idea, this MEU list, but they've also stated that the MEU list is not exhaustive. So that's something that we'll need to keep our eye on going forward as well. There's also the emerging technologies idea and how the government's going to treat national security concerns related to emerging technologies. There's been a lot of back and forth with Congress in terms of defining the emerging technologies, creating a real definition. They've released some categories of products that fall under this emerging or developing technology provisions, but there really hasn't been a definitive answer here. And so we'll have to look at that as we go forward as well. And as always, there's the issue with enforcement actions that target corporations as well as individuals. More and more individuals are getting caught by export control and economic sanctions violations and being sent to jail because of it. Next slide, please. Thanks. For the next few slides, we have a couple charts that we're going to look at, just to look at recent trends in terms of criminal actions. I know earlier Sarah gave a shout out to Ben Sandlin, so this is my opportunity to give a shout out to Kareem Sabadine, who gathered all this data and put together the charts. So here we have actions stemming from violations of the Iranian transactions and sanctions regulations, the International Emergency Economic Powers Act, Export Administration Regulations, Arms Export Control Act, etc. As you can see, Iran and China and Russia are the largest three criminal actions. There were 16 actions in 2019 related to Iran, 12 related to China, and an additional 3 related to Russia. If you go to the next slide, please. 2020, it stayed the same. Still Iran, China, and Russia. 20 actions related to Iran, 13 related to China, and 4 related to Russia. So it's, the trend stays the same. The countries stay the same. And our next slide, please, Jacqueline. is this is just a comparison. It doesn't really change, right? Maybe Iran went up a couple, China went up a couple, Russia went up a couple. It still is increasing, but it's the numbers. These countries still stay the same as we go forward. Next slide, please. Same thing related to civil actions. Now, this is also based on some of the same reports. In 2019, we had 15 actions related to Iran. Now here we have more civil actions related to Cuba, 10 related to Cuba, 7 related to Syria, 5 related to Mexico, and so on and so forth. Notably missing here is China, that is likely part of this other 18%, which is an interesting idea, which is interesting at first, but it may just be because not all the civil actions become public, and so we don't know whether or not there were more civil actions, whereas the criminal actions more often become public. Next slide, please. Similar in 2020, 12 actions related to Iran, 3 to Syria, 3 to Cuba, and then the rest. And the next slide, please, for the comparison. And there you go. Civil actions going down, criminal actions going up on the previous slide. This is basically the trend that we're seeing going forward. Next slide. Yeah, Norm, you want to take it away?
Thank you, Samir. So when you talk about export controls and economic sanctions, you're really talking about an expression of American foreign policy, which changes sometimes, but not all that often. But you see it expressed in some of the headline cases. So this is, again, a qualitative description of what has been going on as opposed to the quantitative charts that Samir just talked about. So here's an example from 3 years ago, ZTE Corporation, again, Chinese equipment manufacturer. It was a huge headline case. The lead announcement was actually by the Commerce Secretary, Wilbur Ross, not the Attorney General, and this was especially egregious conduct. Again, part of the administration's effort to deal with China and remedy some of the things that China had been doing. Next slide, please. In August of 2018, there was another Chinese case. And again, this case has not yet been concluded. There's an indictment of the company, and it's going to play out probably in later this year, or even early next year. But it's a really good example of the issue of collateral consequences, where Huawei has been barred from selling its products to the U.S. government. The U.S. has been pressuring other countries not to use their products. It's a significant component and I think an industry-leading component of 5G networks. And so private sector purchases have been chilled. And so when a company gets caught up in this, and again, the Chinese company, we are having issues with China. It creates these collateral consequences and then reputational risk. So it's not simply the big dollar amount, which you saw with ZTE, but also these other consequences when the government decides to go after you. Next slide, please. So this case, Halkbank, is a very tangled story. I'll give you the highlights. The first person arrested in this saga was a gentleman by the name of Reza Zareb, who is a Turkish Iranian gold dealer, and he was arrested when he took his family to Disney World in March of 2017. And then his co-defendant Mehmet Attila was arrested for reasons. The reasons were clear, but his reasons for coming to the United States, it's incredible that he came after Zareb was arrested, but he did. And he was a senior vice president of Halkbank, which is a state-owned bank of Turkey. And as the case wore on, it achieved a lot of notoriety, both within the white-collar world as well as in the political world. Mr. Zareb hired Rudy Giuliani and Michael Mukasey, who was a former Attorney General of the United States, and they were lobbying high-ranking officials in the in the administration to make a deal and let Zarab out. And in fact, it got so tangled or so political that the president of Turkey, when he met with Mr. Trump, he raised this prosecution and was looking for the president to intervene and figure out something so Zarab could leave. But it didn't work. And then Zarab got tired of being in jail, so he decided to plead guilty and cooperate. Mr. Attila went to trial. He was convicted, and Zarab was the key witness against him. And then the bank was indicted. And the issue now, I mean, there's been a lot of jurisdictional pretrial maneuvering, and the issue now before the Second Circuit is whether the bank can even be prosecuted because it is state-owned and whether it has sovereign immunity. So this is another saga that's going to drag on late into this year and likely into next year as well. Next slide, please. So as Samir referenced, not only are companies caught up in these cases, but so are individuals. And as I mentioned, Mr. Attila, and what's great about his story is that he was incarcerated pre-trial for a number of months, and between good time or time off for good behavior in prison, he was released not too long after the trial concluded. And when he returned to Turkey, he was greeted at the airport by Turkey's Treasury and Finance Minister, and shortly thereafter became the Chief Executive Officer of the Istanbul Stock Exchange. Meng Wanzhou is the eldest daughter of Huawei's founder, and she was arrested in Canada on a U.S. provisional warrant and has been there for the last 2 years plus, fighting extradition, was in custody for a while, and then was released, but is still obviously has her liberty restricted and does not want to come here and get tried along with the company. And these other two examples are presented to you to show you that the government takes these cases seriously. We have sentencing guidelines. The guidelines indicate that light sentences are disfavored for these kinds of export violations to these countries where which are our clear adversaries. Next slide, please.
Norm, if I can just jump in really quickly on that last slide. As you mentioned, these are important to look at simply because if you can go back one, Behruz Beruzian, 20-month sentence, the amount of profits he had in that case were pretty minimal. I think he profited about $35,000 to $40,000 per year, and yet still received jail time of a 20-month sentence, which is pretty significant for an individual. So, small crimes can lead to long sentences.
Right. Okay, next slide. Oh, go back one, please. Thank you. So, not independent, but a lot of times they go together. There's criminal and civil, but these are the pure civil cases, so they're not quite as serious. Willfulness may be lacking. Ofac enforces the rules and regulations about where things are going and to whom they're going. So these are examples of, again, trucks sold to Iran, nothing intrinsically wrong with trucks, test measurement equipment, and then banking transactions. And banking transactions have been a huge issue. There have been other cases where it's been $8 billion or $11 billion in payments for violating Ofac and doing financial transactions with places like Iran. The Keysight example is there because it's very small, but nonetheless, they were gone after. One thing to point out here, the jurisdictional hook is that there are US dollars involved in these transactions, especially with places like Iran, and those dollars get into the US banking system. The transactions may be cleared. It's going through a correspondent banking account. And that's how the US gets jurisdiction. An open question as time rolls forward is, what will be the jurisdictional claim when these transactions start to be settled in Bitcoin as opposed to US dollars? Next slide, please. So civil side, EAR, export administration regulations, this is more the what is being exported. And the first example is an old chestnut. I mean, it's constant, oil field equipment to Iran or to Syria. These get brought periodically. And again, $80,000, $31 million just for 3 violations in Nordic maritime. So the monetary penalties are extremely often, I should say, not always, but often disproportionate to either the number of transactions or the monetary or the profit that was earned in completing those transactions. Next slide, please. And this last category has to do with international traffic in arms regulations, so defense articles that are sent to other countries, and you're supposed to have licenses to do that. But these are cases, they're not now limited to China or Iran, but rather to allies. But they're still not supposed to get these kinds of articles. One feature of these cases, because they are basically defense contractors who screw up, and the government doesn't really want to put them out of business or penalize them excessively. So you see in these cases and in others, there are suspensions of part of the civil penalty. The idea is that instead of giving the government the money as the penalty payment, that the company uses it to remediate and fix the problems so that they don't happen again. Samir?
Sure, thanks, Ron. And in the interest of everyone's time, I'll go quickly through it because I know we want to end at 2 o'clock. But earlier we did talk about DOJ's view on corporate compliance programs. Ofac has issued their own sort of framework for Ofac compliance commitments. A lot of agencies have these types of documents, and there is a lot of overlap between the different agencies' approach. Most of the time, they talk about this risk-based approach to compliance. Using data to look at your size, to look at the size and sophistication of the program, products and services, customers, counterparties, geographic locations, putting emphasis on using resources that are specifically tailored to those areas that pose the highest risk. Ofac outlined their compliance commitments a little bit differently than the DOJ by using this sort of 5 essential component idea, the 5 that are listed here, which it put differently do track the DOJ's corporate compliance program assessment, but is just a little bit differently worded. Next slide, please. So what do all these agencies that we've talked about, what really do they expect from a compliance perspective? The idea is that that companies should have a culture of compliance and that they are good corporate citizens. I like to think that the government understands that when companies are trying to be compliant, mistakes are made, and that may lead to civil violations, but not necessarily criminal ones. When you're not trying to be compliant, you're essentially not a good corporate citizen, and if you're doing things with knowledge of that they could be a violation, then all of a sudden you move on to the sort of criminal arena. The government absolutely understands that inadvertent violations occur, but don't have any sort of patience for ones that are done with knowledge. All these agencies have a voluntary self-disclosure program or methodology where you can go in and voluntarily self-disclose prior to the government commencing an enforcement action against you. It has a severe mitigating impact on penalties. There are outlines of how the penalties can be reduced for a number of these agencies. And so they're definitely expected and encouraged by the government. The idea that you have an existing functioning compliance program is really important. It should be proportionate to a company's risk profile. And like we've talked before, there's no such thing as sort of a one-size-fits-all. It really needs to be adapted to your own corporate risk and your risk profile. Next slide, please. Just wanted to finish the presentation by looking at sort of President Biden's approach compared to his predecessor. I don't know how much it's really going to change. Maybe the methodology or how the approach of approaching China may be different, but the reality is China will remain in the crosshairs. Russia will remain in the crosshairs. Venezuela, Iran. Those countries will remain sort of in the crosshairs of the United States government. It's just that how President Biden and the administration approaches it could be different, with more negotiations rather than simply putting together actions that could hurt both the other country. There's going to be we're going to continue to want to be tough on China and still focus on sectors that impact the national security concerns. Next slide. I think that's it.
That's it.
Yep. Thank you, everybody. Yeah, go ahead, Norm.
Yeah, I was going to say, this is the most important part. I mean, we haven't seen any questions, but the tracking code number 2 for the second hour is displayed Thursday, CLE, capital C, capital L, capital E, all one word. And to repeat the first one, it was WCC 2.18, WCC all capitalized. Okay, great. Thank you very much, everyone, for attending. And our second part will be on March 18th at noon. And we hope you all can attend and hear about those subjects. Thank you again.
Thank you.
Thanks, everybody.